Ever wondered how assets are divided in a California divorce? Generally, the law stipulates a 50-50 division of assets and debts. It sounds straightforward, right? But what if I told you, it's not always a straight 50-50 split? Imagine this. John and Jane, a Californian couple, have decided to call it quits after 10 years of marriage. They have a variety of assets between them, a family home, a couple of investment properties, and a joint business. Now they could opt for the standard 50-50 split, but they've decided to take a different route. John has a deep attachment to the family home, while Jane has always been the brains behind their real estate investments. So they choose an alternative route. John keeps the family home and Jane takes ownership of the investment properties. They agree to co-own the business. This arrangement may not be an equal split on paper, but it works for them. It's their personal balance of fairness. And guess what? The court is fine with it too. As long as John and Jane both sign off on this agreement, the judge will accept it. In the end, it's all about reaching an agreement that both parties find satisfactory. So, what have we learned from John and Jane's story? Well, first off, we've discovered that the general rule of a 50-50 asset division in a California divorce isn't as rigid as it appears. Yes, it's common, but it's not a must-be-followed rule. What's crucial is that both parties agree to the terms of the division, whether it's an even split or not. Secondly, and perhaps most importantly, we've learned that the court essentially takes a hands-off approach. As long as you and your spouse have signed a settlement agreement, the judge won't step in to assess fairness or equality in the division of assets and debts. The court respects your decision-making autonomy. Remember, the power to decide lies in your hands, not the court's.